Gary Wayne Sutton is scheduled to die by lethal injection later this year. Last week, a judge ruled that experts will have to examine Sutton before the death penalty process can move forward. 6 News anchor Lori Tucker brought in our legal analyst Greg Isaacs to understand how this step fits into a saga that has gone on now for 3 decades.
Greg, thank you for joining me.
Lori, it's good to be here.
Sutton was convicted and appealed several times over the years. So what is the point of this evaluation all this time later?
The double homicide that occurred in the early 90s, Sutton and his co-defendant, they committed a crime that occurred in both Sevier County and Blount County. He was convicted in Sevier County and given a life sentence, but in Blount County, a sentence of death. And while he's been awaiting execution on death row, the constitutional litmus test on the 8th Amendment prohibition against cruel and unusual punishment has changed. In Atkins versus Virginia, the Supreme Court has said it is unconstitutional, unlawful to execute someone that suffered from an intellectual disability. Tennessee followed suit, and we changed the law in 2021, and now Judge Dugan in Blount County has allowed the defense to have an evaluation, and Lori, they are trying to fight to get Sutton off death row decades later.
And when we talk about that, because that's the key point here, when we say exonerated, that doesn't mean, hey, you're going to go free. It means he'd probably get life in prison, correct?
Well,
this was just saved his life.
What they're doing, what the purpose under the constitutional mandate in Tennessee state law is to determine via a forensic psychological and psychiatric evaluation whether Sutton suffered from an intellectual disability during his developmental years. So they're not going to determine whether he's competent to stand trial.
Right, they're looking at how he was when the crime was committed.
Or
that's hard to do.
Whether he was suffering from a mental disease or defect that got into not guilty by reason of insanity. No, this is just to put his behavior in context. And here's what the court justified that rationale on, that being the U.S. Supreme Court. One, people of low functioning intellectual disabilities are more likely to be falsely convicted. Also, there's less of a general deterrent effect, which is a big consideration in capital litigation for others if someone is executed that was low functioning. So basically, his lawyers at the time didn't vet that defense, and so now you've had the lawyers, you've had appeal after appeal, and now it's going to be the experts to present a case that he's intellectually disabled. Is it going to be viable? Interestingly, a few years ago in Memphis, in the Payne case, an individual had his sentence commuted from capital sentences in a double homicide to life without parole.
And he was convicted of killing a mother and her child.
Right, but the same defense. So now it's going to be interesting. This execution is set for December 3rd. A lot of procedural hoops, but it's in the hand of the experts.
All right, we'll be watching. Greg, thank you.